Guarantor is before my lords.
Who's before my lords?
The guarantor is the petitioner
Guarantee.
before my
ಯಾರಾದ್ರೂ ಏನಂತ?
Yes, my lord.
Yes.
My lord, what happened, my lord? Original application was filed before the debt recovery tribunal, my lord,
Hmm.
against the borrower as well as the guarantor, my lord.
Hmm.
Then, my lord, the guarantor immediately approached the jurisdictional police and lodged the complaint regarding the collusion between the bank as well as the borrower, my lord.
Hmm.
Charge sheet came to be filed. Blue collar notice has been issued against the borrower
Hmm.
because he has defrauded many people, my lord.
Hmm.
Then, my lord, I filed a suit, my lord, to
Hmm.
declare that, my lord, I am discharged from all the liability as well as section 133 and 134 of the Indian Contract Act, my lord.
Hmm.
Then the suit came to be rejected, my lord, at the instance of the banker, my lord.
Hmm.
Then I preferred an appeal before this honorable court. This
Hmm.
honorable court came to a conclusion that there is a prima facie case regarding the fraud, my lord.
What
Then
happened? Remand ಆದ್ಮೇಲೆ ಏನಾಯ್ತು?
Remand admel suit is continuing, my lord. Then I filed an application before the debt recovery tribunal.
Hmm.
Hold the proceedings till the disposal of the suit.
Hmm.
Then that application came to be dismissed.
Hmm.
Then I preferred an appeal before the DRAT.
Hmm.
That appeal also came to be dismissed.
Hmm.
Then I filed a repetition before this honorable court.
Hmm.
This honorable court observed that both the proceedings shall continue. In the event if the DRT come to a conclusion that there is a liability to be fastened on the guarantor, then the proceeding has to be stalled insofar as the defendant number 9, that is the guarantor, my lord.
Hmm.
At that point of time, when there is a stay, when those proceedings were at that particular stage, my lord,
Hmm.
I filed an application
Hmm.
seeking for the cross-examination of the banker, my lord. That application came to be rejected. Then I filed this repetition, my lord.
Ah.
My submission is that, my lord, on 2 occasions, this honorable court has come to a conclusion that, my lord, the fraud is the prima facie case of fraud has been made out, and collusion between the banker as well as the that has been assigned from time to time, my lord, when that bank was closed, that was stripped to core by the DBS. DBS has assigned the entire their right in favor of.
Now, who do you want to examine?
I want to examine the banker, my lord. I have to
Which-
cross-examine him.
Ah.
AW1. I request my lord to
Where,
kindly take
who is that?
the banker, that particular name, my lord.
Hmm.
AW1, my lord. I will just,
AW1 is the name. Ah?
no, that is the,
Hmm.
as a witness, he has been, I
So
request my lord.
who objects to that?
Sorry, my lord.
Who is objecting to that?
The bank, the bank is objecting for that.
Which
And
bank?
they have made, my lords. And on 2 occasions before this honorable court, my lord,
Hmm.
the banker has made a statement that I have every opportunity, every right to cross-examine and conduct the trial before the DRT proceeding.
No, no, it is
And
not
then
correct.
this particular, they have opposed before the debt recovery.
My lord, I may permit you to file a
Where
case.
is that?
Case
Finding.
She so and so, learned counsel appearing for the defendant number 2, submitted that appeal was not tenable either on law or on facts. Instead of seeking permission to cross-examine AW1 and for leading his evidence, plaintiff herein has filed OS number so and so seeking for certain declaratory relief, which was not maintainable in view of bar under section 34 of the Act. Now, my lord, they filed objection to my application,
My lord, may I
having
make
made
one
that
submission?
statement.
34 is also
And-
connected
and
matter.
after
One
that,
minute, 1 minute. Who instituted OS?
OA, my lord, myself.
1 minute.
suit I have instituted.
OS.
OS 19 you have instituted.
Yes, ma'am.
All right. This, instead of seeking permission to cross-examine AW1
Yes, ma'am.
for leading evidence,
Yes, ma'am.
on whom is this remark?
This remark is on me, my lord,
Ashtata, not on them.
not on us.
Sorry, yes.
That is the contention. That is their contention. And
Oh, that is
having
a
made,
contention, all right, of the bank.
having taken that contention,
Who is the second respondent is,
the banker, my lord. Not only here, my lord, one more proceedings. That is with respect of stay of the proceedings which I sought for.
yeah, that's all right. Yes, what's
My lord,
wrong?
my lord,
Why are you fighting shy to get cross-examined?
But it's contrary to.
Tell me, why are you fighting shy to get cross-examined?
Contrary to order made by this honorable court division bench, I'll just
ಅದ್
point
ಕೊಡಿ. Cross-examine ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
out ಅಂತ ಇದೆ.
ಕೊಡಿ.
I'll just point out.
ಕೊಡಿ.
But it is not the. My lord,
ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದ sentence ಗೆ ಹೋಗಿ straight away.
No, my lord,
Don't beat around the bush. Straight
my
away
lord, I
that
filed-
sentence.
My lord, give me, my lord,
Straight away that
give me two-
sentence.
My lord, I'll just point out, my lord, the sequences in this matter.
Ah.
2010, the my lord borrower availed a loan. My lord, the first, my lord, kindly see.
You
And
must
2011,
be
my lord,
aware that charge sheet was filed against.
charge sheet not filed against me, my lord. I made a very specific submission before the division bench.
Hmm.
I am not aware. That submission, my lord, I made before the division bench also. I was not aware. Maybe charge sheet against my lord, the principal borrower, which I was not aware. My lord, kindly come to my lord, tableau number 5. Petition executed a
ಅಲ್ಲ,
guarantee.
You are the assign or no, assignee rather.
House.
Yes. Hmm.
My lord, petition executed, my lord, set of documents in my favor.
Where is the division bench that you should not be cross-examined?
That is 6. ಅದಕ್ಕೆ ಮುಂಚೆ I'll just show there, my lord, it is their admitted debt before the DRT They filed a written statement.
You said, division bench has said you should not be cross-examined.
My lord,
Where is
my lord,
that?
I'll just point out, my lord, before the, my lord,
No
kindly come,
history, straight away to that
kindly come,
sentence first.
kindly
Amal, I'll let
page
you
number
argue.
59, order passed by the division bench.
I am at page 37,
There is a copy code.
36, tell me.
39, 36 is the, my lord.
All right,
14, my lord, I
39,
made
where
a
is it?
submission before the division. What had happened, my lord, I'll just point out. I filed, my lord, original application before the DRT.
Hmm.
My lord, DRT, they appeared before the DRT, they filed the written statement and they admitted, my lord, initial loan of rupees 7.5 crore because it is a registered mortgage executed in favor of, and there, in fact, in respect of 7.5 crore, it is admitted debt. Subsequently, there is announcement wherein, my lord, guarantee, my lord, executed, and, my lord, there are set of documents also executed, it is not registered document. Their case is, my lord, subsequent, my lord, there are announcement taken place, I am not the, my lord, a part of it. That is their case. Then, my lord, I parallelly, my lord, I initiated action, my lord, I'll just point out, my lord, the mortgage deed. Before we come to, my lord, first para, we mortgage, the very same petitioner executed document, or it is a registered document, my lord, 20th/7/2011 at so and so, and my lord, kindly come to the next page, my lord, the schedule of the property. Very same, my lord, property.
Hmm.
Subsequently, what had happened, my lord, in the year of subsequently that account became NP and I filed a suit before the DRT, where, my lord, they filed a written statement. And, my lord, along with, my lord, OA, I initiated action under Surface Act.
Hmm.
Surface Act, my lord, they filed a suit before the civil court. Initially, civil court granted an interim order. We appeared, we filed an application under Order 7, Rule 11, read with Section 34. Civil court rejected the petition.
Hmm.
Subsequently, they appeared before, they filed an appeal before this honorable court in RFA. Madia is, my lord, only at the context of Surface, not because of, my lord, added fact. In view of Madia, if any allegation on fraud, then civil court has to decide. Then, my lord, matter remanded to civil court. My lord, later,
Hmm.
my lord, we choose that we will not initiate the Surface Act. We will proceed the matter before the DRT only because the suit is pending from 2015. Suit filed subsequent to that 2019 or 2020. My lord, we pursued the action before the recovery officer, presiding officer. Before the presiding officer, they filed an application for, my lord, stay the proceedings.
Hmm.
That, my lord, that honorable civil DRT said, my suit is 2015. Their suit is in there of 2019. Therefore, suit has to continue. OA has to continue. That, my lord, they assailed before the DRAT. That is at, my lord, this order assailed before this honorable court before the division bench. That is at, my lord, page number 36. This, my lord,
Hmm.
considered by this division bench, my lord, we have argued both the party. We have argued at length. In fact, my lord, whole day we have argued before the division bench.
So what?
My lord, the honorable division bench, my lord, kindly come to page number 39 for a moment. 49. In fact, my lord, the honorable division bench accepted that cross-examination, there is no power under section 22. It's all,
You take me to that sentence I'm asking you. Without that, you're beating
my
everywhere.
lord, kindly come to, my lord,
Take me to that sentence where cross-examination is denied.
may make one submission for, that is a,
Don't beg
No,
the question.
not
I'm
a-
asking
that
you,
is
where
not-
is that
my
sentence?
lord, the very same word, my lord, we mentioned before the division bench, my lord, it is not recorded. However, my lord, the very same, we made a submission, court said it is not possible. Section 22 is not provides. But I just point out, my lord, page number 49 9 for a moment. In both the circumstances and the above observation, this writ petition is disposed of. Page number 49, my lord, last para. Both the civil court in respect of Surface and debt recovery tribunal are requested to try and dispose of the subject cases within an outer limit of 1 year. All the contention of the papers are kept open. This court places on record appreciation of performance of learned counsel for the petition, Mr. So and so. Honorable division bench said that, my lord, you go before the DRT as well as civil court. And, my lord, as far as possible, my lord, the matter has to be dealt. Lord, I'll just point out two things. When this order passed by the division bench, this present writ petition, my lord, today we are arguing pending before this honorable court. The learned counsel would have pointed before the very same aspect before the division bench also. My lord, this petition, he kept it as, my lord, backup. In fact, my lord, he never, my lord, made a submissions in respect of this writ petition.
You should have made.
No, my lord, that
You should have made.
my lord, my lord, in fact, I'll just, my lord,
Our backup ಆದ್ರೆ ನಿಮಗೆ ಮೇಕಪ್
my lord, in
ಮಾಡ್ಬೇಕಾಗಿತ್ತು
fact,
ನೀವು.
when initially the matter came up before this honorable court, it's not the first time, my lord, matter coming before this honorable court.
You should have told the division bench, sir.
My lord, when they are not seeking their relief because
Arre, you said they deliberately did not tell about the pendency of this petition. What were you doing there?
my lord, when they are not interested,
You
their
were not
relief-
aware of
when
this
they are
petition?
not interested, their relief, my lord. In fact,
You should, that should have been your submission.
my lord,
That deliberately they are not mentioning about this.
that is one.
Ah.
My lord, in respect, my lord, now I'm just pointing out, my lord, two
Hmm.
aspects. One, in respect of cross-examination, my lord, kindly point, I'll just point out the order passed by the DRT for a moment. My lord, if my lord permits, my lord, serial number 34 also, my lord, one more petition filed by the very same petition, very same.
Having spent this much time, I will not adjourn it. Tell me.
No, I'm not seeking an adjournment. I'm
Pass
reading the
over
matter.
also ಇಲ್ಲ
ಅಲ್ಲ,
ಹೇಳಿ.
34, serial number
ಪರವಾಗಿಲ್ಲ ಅದ್ ನೋಡೋಣ ಆಮೇಲೆ.
ಅಲ್ಲ, my lord, what had happened in this matter? No, my lord, before the DRT, the matter is posted for argument. In the year of 2024, it is not in dispute. My lord, I'll just show the, my lord, DRT order sheet for a moment. My lord. There are 10 adjournment taken.
So what?
2021,
Hmm.
1, 2.
Hmm.
Thereafter, my lord, total 10 up to 2024 for leading their defend evidence. In this juncture, my lord, after matter posted for argument, now they can't come and say that, my lord, I have to, my lord, do a cross-examination. And my lord, I have to, my lord, take a defense. In respect of, my lord, debt, it is their own admission before the DRT. The Honorable DRT said, my lord, the DRT reasoned it. Why, my lord, what document, my lord, they wanted to, my lord, placed on record. It is taken on record. From the aforesaid institution, the tribunal has not called an explanation with reference to the same. So far as therefore the relief prayed in IA number so and so premature, hence rejected. That Honorable Supreme Court says that, my lord,
I've read it, sir.
my lord, it says that all are record. Bank, my lord, nothing oral. My lord, everything will be record. We placed all the records in the year of 2015 before the DRT. It is not in dispute, my lord, they availed a loan. It is not in their own admission, my lord, they executed a mortgage and given the documents in favor of the bank. It is all, my lord, we have placed before the DRT and they filed their defense. And their complete return statement has been taken on record. And now, after taking 10 adjournment for leading their evidence, now and that matter, my lord, before the Honorable Division Bench, it said that within outer limit of 1 year that has to be decided. Now they are filing the multiple application. Kindly see how many applications before the DRT now. The intention of the, my lord, the petition is to only drag. From now it is 10 years. 10 years from the suit, which I filed in the year of 2015. It is said not, my lord, kindly see there are 10 adjournments. It is not, my lord, OA, my lord, under section
10
19.
years, 10 adjournments.
Allah, my lord, there must be some, my lord,
I'll reason it out.
there are,
No
my lord, this case, my lord, is one of the classic case.
Classic case, that's
My
why
lord,
I'll reason
This
it
is
out.
one of the classic case where, my lord, they are availing the loan and subsequently, my lord, one after one.
Why are you fighting shy of cross-examination? That's all is the question.
Lord,
Why are you fighting shy of rule 22 or
law not permits.
sub-rule 6 of
When-
rule 12? That is not an unambiguous embargo. It is discretion.
My lord, it is-
I'll quote the Supreme Court itself,
My lord,
sir.
I'll just continue, my lord, kindly permit me one
Supreme
more.
Court, proviso, go to the proviso of rule 22.
Kindly come to page 55, para 23 of the judgment.
No, now I'll answer that.
If you ask everybody, no, my lord, after my lord deciding the matter by division bench, they would have pointed out disrespect before the division bench. Now, my lord, after my lord division bench pass an order in my favor, now they can't go and file an application after there are 6 applications pending for the DRT now. The only intention, the even though my lord, that would have been the case. They would have challenged that order before the my lord, the Honorable FX Court. They are accepted that order. Now, my lord, filing one after an application before the DRT saying that I have to send the document for forensic lab. That truth report, that report given by somebody, my lord, it has to be summoned. It is not permissible in law.
Oh.
One aspect. My lord, I'll come to the point. There are 90 crore, my lord, as on today outstanding.
I am not on outstanding. I'll tell you one thing. What is being sought is cross-examination. Your submission is that the rules does not permit, Supreme Court says so. It is only on the basis of documents and affidavits filed.
Please.
All right. Now, here is a case where he has alleged fraud. Charge sheet is filed by the police. 1 minute.
I will make myself.
Borrower with whom?
Against the borrower. And the allegation is that collusion with the employees of this bank.
All
And they are
right.
further investigating into the matter.
All right. So that is pending. It is not in every case this is permissible. We will carve out an exception to be a classic case where
That
cross-examination is
being the case, my
necessary.
lord, kindly take along with serial number 34, one more matter in the very same matter.
Adal ಏನ್ ಹಾಕಿದ್ದೀರಾ application?
My lord, what
Other application.
what I did, my lord, I filed an application to produce the expert opinion of the Truth Lab, where there is a fabrication of the document, fabrication of my signature. Truth Lab gave a report saying that, my lord, there is a fabrication of my signature, and that particular report I placed it on record, and I filed 2 applications to receive that particular report on record, then summon that particular Truth Lab report author who has given this particular report as a witness, and to mark this particular document. This document is taken on record, and then the court has said that it will be considered at the final stage. Now, my lord, under section 45 of the Indian Evidence Act, I have to mark this document, then only it will be exhibited. That particular application came to be rejected, summoning of that particular author. If I have not exhibited, my lord, this particular document will not be considered. And for that reason, my lord, I have filed that particular petition. And even that application came to be
Sorry,
rejected.
ಅದರದ್ದು argument ಆಗೋಯ್ತು.
My lord, kindly come to page number 60 of their writ petition before this honorable court. Their written statement. I'll just point out.
Sir,
Because
this court, 1 minute. This court for one will not leave anything unturned in the sense examination, cross-examination and all opportunity to whoever it is must be either in criminal law or here. Here, the case, ಈಗ truth labs ಇಂದ you have taken that 1 minute.
ನಾನ್ ತಗೊಂಡಿದ್ದಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು,
There is-
ನೀವಲ್ಲ, whatever instance, he will have to prove his defense.
It is
That
already
is
before the-
forgery has happened. Should he not prove?
It's already before the DRT, my lord.
It is already before the DRT. How can the DRT dismiss that application?
No, my lord. No, DRT
How can
said-
DRT do
No,
that?
my lord, kindly see that DRT said, I'll consider that truth lab report
ಯಾವಾಗ? After everything is over?
at the time of final argument.
Why final argument?
There are, my lord,
1 minute, sir. At the time of final argument, DRT is going to consider this report, oh, this is not forgery. Should not the man who has given that opinion be examined?
my lord, that being the case, my lord, they would have taken up this issue before the division bench when the matter was pending. My lord, kindly see the date of filing this petition,
Idu-
not now.
Yes. What is the date of application you filed before the DRT and Truth Labs report date? ಏನು?
Yes, my lord. Truth Light report date, my lord. February 2025. my lord.
What is the date of the division bench order?
Division bench order, my lord. 27th January 2025, my lord.
ಅವ್ರಿಗೆ ಕನಸು ಬಂದಿತ್ತಾ?
Lab report ಅಲ್ಲ, my lord. If
ಮತ್ತೆ
this-
ಇನ್ನೇನು?
When this writ petition has been filed before this one.
ಹಾ.
This writ
This
petition
writ
filed-
petition is
this
pending.
writ petition
No
is filed,
problem. All right.
this
You
writ-
should have told the division bench, sir.
my lord, my lord,
ಅಲ್ಲಿ absolute silence, ಇಲ್ಲಿ violence.
ನಾನಲ್ಲ, ಅವ್ರು violent, my lord,
ಹಾ.
silent. I was not,
Yes.
my lord, the matter was heard whole day, that
Hmm.
we have pointed out all the
Hey,
aspects.
whole day ಏನ್ ಮಾಡಿದ್ರಿ ಇದೇನಾ?
We have pointed out all the aspects.
You should have
On the-
pointed out this aspect.
My lord, against the division bench order, my lord, SLP has been filed. And they say that they are not aggrieved and that order is in their favor.
SLP in respect of, my lord, the civil, my lord, in respect of that RFA, not, my lord,
Hmm.
we are, in fact, we sought this very same relief from the
Yes,
division bench, which is granted. Why I'll go for SLP against that order, my lord, it's not so. My lord, I'll just point out. This writ
ಇನ್ನೇನ್
petition-
point out? Pointed out everything.
Hey, my lord, the
Yes.
risk petition filed on, my lord, 20th/5/2024.
So what?
This relief
You
would have-
should have told the division bench, sir.
Lord, I'll.
You were aware of this writ petition. What stopped you from telling?
My lord, in
Why
one-
were you tongue tied
One case.
before the division bench?
One case, which was.
Why?
My lord,
Why?
that issue was something.
You are pointing at him that they did not bring it to the notice. Why did you keep quiet? ನೀವಲ್ವಾ ಅಪೇರ್ ಆಗಿದ್ದು?
ನಾನು appear.
ಮತ್ತೆ ಯಾಕೆ ನೀವು ಅಪೇರ್ ಆದ್ರೂ ಹೇಳಿಲ್ಲ ಅಂದ್ಮೇಲೆ ಅದ್ಲೇನು ಇಲ್ಲ ಅಂತ ಅರ್ಥ.
No, my lord, in fact.
ಯಾಕೆ ಹೇಳಿಲ್ಲ?
In fact, I'll just.
Why?
I'll just point out two things.
Yes, sir.
It will become a kiosk. The reason is this.
Why you did not tell?
My lord, in fact, my lord, they would have pointed out, they're not able to get a relief in before this one.
Leave it, sir. ನೀವ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಇದೇ ತರ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಇದ್ರ ಬಗ್ಗೆನೂ ಬರ್ಸ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲೇನೆ.
That being the case, my lord, that writ petition, my lord, against that order passed by the DRT, they gone to DRAT. DRAT, they.
ಎಲ್ಲ
suffered-
ಆಯ್ತು. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ವೈ ವರ್ ಯು ಸೈಲೆಂಟ್? ಅದಕ್ಕೆ ಉತ್ತರ ಇಲ್ಲ.
ಅಲ್ಲ, it's not that, my lord. In fact,
ಏನು?
division bench considered all the aspects.
ಸರಿ, why you did not bring this writ petition pending aspects?
Their writ petition, my lord, they're not interested, my lord, relief.
Hey, why are you bothered about them, sir? You should have bought it.
In this juncture, my lord, they can't ask this relief.
See, that's
My lord, kindly
why,
take-
that's why when you have a difficult case, these things happen.
No.
That's all right.
My lord,
No problem. Will pass orders.
34 ಜೊತೆ ತಗೊಳ್ಳಿ, ನನ್ನ lord, I have made. some more
34
submission.
ಜೊತೆಗೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಆ 34
But,
ಡಿಕ್ಟೇಟ್
my lord, I
ಮಾಡಿ.
have to make some more submission in serial number 34.
Some more?
My lord,
No time, sir.
My only difficulty is 26th is the date. my
I am
lord.
going to stay everything there. Yes. I'll stay at 34. Yes.
wait.
ಅಷ್ಟ್ರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗಿ ಬರಂಗಿದ್ರೆ ಬನ್ನಿ.
Division bench
Yes,
order, they
next.
accepted. Division bench said matter has to decide within a period of 1 year.
Yes, sir.
My lord, they are accepted and coming and filing one more writ petition. It is, my lord, nothing but abusing the process of law. My respect to
Which
submission
writ
before-
petition? 34.
ಅಲ್ಲ, ಹೌದು, ಅಲ್ಲ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದ್ಮೇಲೆ ಒನ್ ಮೋರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಯಾವ್ದು ಹಾಕಿರೋದು?
That 34.
ಯಾಕೆ ಹಾಕಿರೋದು?
ಯಾಕೆ ಆಗಿರೋದು?
ಹಾಕ್ಲೇಬಾರ್ದಾ?
It's not so, my lord.
DRT ಏನ್ ಮಾಡಿದ್ರು ಸುಮ್ನೆ ಇರ್ಬೇಕಾ?
Subsequent to that, the honorable division bench said,
No,
you
no.
have to decide the matter within a period of 1 year.
ಹೌದಾ? ಕರೆಕ್ಟ್.
They-
ನೋ
thereafter
ಪ್ರಾಬ್ಲಮ್.
they filed.
ನೋ ಪ್ರಾಬ್ಲಮ್. ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದ್ಮೇಲೆ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ರಿಪೋರ್ಟ್ ಬಂದಿರೋದು. ದಟ್ಸ್ ವೈ ಆಸ್ ವೆನ್ ವಾಸ್ ದ ಟ್ರೂತ್ ಲ್ಯಾಬ್ಸ್ ರಿಪೋರ್ಟ್?
My lord, I to understand. If the
If you
borrower
understand,
does
then you
not
should not
executed
argue
a
that.
document, borrower said that no point of time I am given a mortgage. Borrower said, my lord, I have not given this original documents to the bank. Everything they are admitting. 2010, my lord, when they rebelled, registered mortgage, otherwise, my lord, that also they would have denied.
See, if you had said yes, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಲಿ ಪರವಾಗಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಟೈಮ್ ಲಿಮಿಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಎಲ್ಲ
ಆವಾಗ,
ಮುಗಿಸ್ಬಿಡ್ತಾರೆ.
my lord, they would have
That's the
2022, when the matter gone for defend evidence.
When
that's
you
what they would have filed an application.
argue on points that are absolutely weak,
My lord,
this is what will happen.
2022, when they
Now I
filed the
can't
defendant
help.
evidence, the
Yes.
matter is posted. That time they
Problem,
would have
sir.
filed an application for cross examination. I
That
don't
if the
understand.
division bench has directed disposal within 1 year, it is not disposal it is disposal in accordance with law, not driving him without any opportunity. That can't be the scene at all. ನೀವು ಅಲ್ಲಿ DRT ಇದೇ ತರ ಗಲಾಟೆ ಮಾಡಿದ್ದೀರಾ, ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
I am not permitted to lead my evidence also. my
Yeah,
lord. That
that's
application
not-
is also.
That I pointed out 10 adjournment given by the DRT, my lord, on the record
All
we produced
Corona, my lord,
10
because
adjournment.
during Corona, my lord.
24 ಯಾವ corona sir?
ನಾನು ತೋರಿಸ್ತೀನಿ ಅದನ್ನ. And the court on 2 occasion, my lord, has kept the matter reserved for 2 years. And date is not given, my lord. On one particular date, that particular order was pronounced. Then, my lord, later we have come to know, then we have appeared. I can file the affidavit to that effect also.
You want the affidavit to come?
It's all procedure. My
Procedure.
lord, first and foremost, my lord,
Yes, it's all procedure.
earlier proceedings, my lord, they
Uh,
gone
it
before
is
the
all
DRT, it
procedure.
came
I
to
am
high-
also telling the DRT should follow procedure.
My lord,
Truth Labs, see, there is a report of a laboratory that says his signature is forged. All right? That forged signature, opinion of the handwriting expert, whoever has taken should not he be examined?
my lord, the
And
summary
DRT
proceedings-
says final hearing noಡ್ಕೊಳ್ಳೋಣ.
respect of my lord, National Company Law, DRT, my lord, it's all summary proceedings, where my lord, DRT taken on record, even though. they
Exactly. Generally, it is summary proceeding. But exceptionally, when such fraud is alleged, it can't be on the grounded summary proceeding, we can't brush away everything.
And out, my lord, we are assisting. When my lord, account become NPA, all the guarantor will have a same song.
ದುಡ್ಡು
My lord-
ಬಿಡಿ. See, same song, whatever it, you're borrowing my words.
I'm
All
so sorry,
right,
I'm so
leave
sorry.
it. No, that's okay. So it may be same song, different song because of the cross examination being denied. 34 ತಗೊಂತೀನಿ, dictate ಮಾಡ್ತೀನಿ.
Then virtually, my lord, that division bench order will become, my lord,
Division bench, I will write, sir. Division bench said disposal is in a particular period, but not contrary to law in accordance with law. Cross examination ಬಿಡದೆ ಹೋದ್ರೆ ಇವ್ರಿಗೆ ಹೆಂಗೆ?
that being the case, my lord, I'll just point out, my lord, few dates, which, my lord, they are taken
34.
adjournment before the DRT, my lord, at
34.
this, 30, wait.
Yes.
And one authority from the Supreme Court. in
10
respect-
authorities you give,
Wait.
sir, no problem.